Hi, everybody. This is Alexandra Rizzio from the Safe Passage Project. I am the senior staff attorney here, and I'm thrilled to welcome the two editors of the recently released book, Protecting Migrant Children in Search of Best Practice. They are Professor Lenny Benson, professor at New York Law School and founder of the Safe Passage Project, an organization dedicated to the principle that no child should face the immigration process alone. We also have with us Professor Mary Kroc, professor of public law at the Faculty of Law, University of Sydney. Mary also founded a not-for-profit as a young lawyer in 1989, which is now known as Refugee Legal. She has been chief examiner and head assessor in various specialist accreditation programs in immigration law across Australia since 1994, and has been listed in the peer-appointed publication Best Lawyers in Australia in Immigration Law every year since 2008. We're thrilled to welcome them as we get the webinar underway.
So a few years ago, Professor Kroc and I undertook this book project because we were both focusing our academic and professional volunteer experience on the movement of migrant children. And the book contains 24 chapters, does document and illustrate the global dimensions of this problem. The opening chapter contains statistics on the International Organization on Migration, but also we have chapters on Australia, Canada, the UK, the EU, the US, a chapter on Kenya, and a piece addressing children in China. In the year that ended in September 30, we know, those of you in the US, that along our southern border alone, more than 58,000 unaccompanied migrant children were taken into custody by the Border and Custom and Border Protection. And just this last month, another 5,000. I'm going to turn now to Professor Kroc. Did I have that right? Yes. Turning now to Professor Kroc to give us a discussion for the next 10 minutes or so about the framework of the book, which shapes the discussion of migrant children first in terms of international law. Professor Kroc.
Well, thank you, and thank you everyone for joining us today. It's very exciting to have you here. I'd just like to add to what Lenny said. This is a comparative law book at one level, but at another, it is a book that should give everyone everywhere structures to work with in practice when you're dealing with migrant children. You see, as I hope we'll show you by the end of this webinar, you have a pretty unique experience in the US with the number of migrant children who are coming here, but the issue is that this is a global phenomenon. It's happening all over the world. As we speak, for example, there are 65,000 unaccompanied children in Sweden. I got interested in this area in 2004. In that year, the US was receiving between 4,000 and 5,000. So what we've seen is that the US has literally had a 10-fold increase in the number of migrant children coming here, but all around the world, this is happening. Families are sending their children abroad to seek protection. So what does international law have to say about this? You as practitioners will of course be aware of the Refugee Convention. You'll be aware of some of the human rights conventions, such as the Convention Against Torture, because that underpins your CAT claim. So you even use the same acronym in this country. Many of the children that you and I have helped over the years have got protection by showing that they somehow cram awkwardly into the definition of refugee. This year, you should be aware, is a big year for migration and international law, because this year, all of the countries of the world, and I'm sorry that the US decided not to be part of this, have come together to form a compact on migration and a compact on refugees. The compact on refugees was actually concluded in September under the umbrella of UNHCR, which is the UN agency responsible for looking after the 59 million persons who are displaced by war and conflict around the world. In December, the nations come together again in Marrakesh, and that concerns migrants generally, not refugees. I'm actually disappointed that there's a separation between refugees and migrants, because you put a child on the road and they very much have the same problem. That process in Marrakesh has been overseen by the International Organization for Migration, and many of you will be familiar with that, I think. The IOM this year, for the first time, has ceased to be simply a gun for hire, working on behalf of individual nations, and it's become an agency of the United Nations. Why is this important? Well, it's important because agencies of the United Nations, as indeed countries everywhere, when they're presented with a child, have to comply with basic precepts of international law. Now, I hope that you're aware that the most important convention for children anywhere in the world is the Convention on the Rights of the Child. We refer to it as the CRC. I've put up here for you Article 3.1. We start our book with 2 chapters on the international regime, and the first chapter looks at the Convention on the Rights of the Child, focusing really on Article 1, which embodies the core principle of that in all actions concerning children, the best interests of the child shall be a primary consideration. Now, you may also be aware that for each of these human rights conventions, they have established a committee of international experts that come together throughout the year.
Hi, this is the moderator. If you could please mute yourself as you join the call. Thank you.
Who come together to make pronouncements about the international conventions. So the Committee on the Rights of the Child has actually come together with another committee responsible for migrant workers, to create a comment, general comment as they're known, which is it's regarded as soft law, soft international law. So it's persuasive, but they've made the point that the best interest of the child is a right in every child, whether they are legal or illegal, whether they're migrant or whether they're nationals, that it is a principle that should govern everything that governments do and indeed that we do. So I'm going to sell this to you as a convention you ought to read just to treat your own kids better. And at the end of this, when I finally sit down and shut up, we're going to talk about process, because I think in many ways, once a child engages in the immigration regime, whether it's here, Australia, or anywhere else, the best interest of the child has to be core to the procedures that are followed. Now, I've got a couple more slides for you. The thing about the CRC, the Convention on the Rights of the Child, is that unlike earlier human rights instruments, which were very much about doing the right thing and looking after people, you know, protecting them even if they didn't want to be protected, sort of thing. The Convention on the Rights of the Child, however, says children not only have all of the human rights that have been set out in all of the international instruments, but they've got a right to be heard. They have a right to participate. And that really flips the whole argument, because instead of looking at an idea that somebody needs help, you've got to actually walk in the shoes of the child and see what can they do, what are they understanding, and what's their view on this. They have a right to participate. I want to briefly make some comments about another convention that is one of the most recent of the Human Rights Convention, I had the good fortune and privilege of being involved in the establishment of the Committee on the Rights of Persons with Disabilities through my husband, who was chair. The point I want to make is that the CRPD convention was very much modelled on the CRC, but it was the first convention in which express acknowledgement was made of persons with disabilities. Can you believe it took until 2008 to actually expressly acknowledge that persons with disabilities are human beings who should be treated in the same way and have the same rights as anyone else? And there again, the core principle of the CRPD, very much aligned with the CRC, is to say that disability is not about impairment. You know, I have short-sightedness and I have another eye condition that I get treated every 3 months for. If I don't get that treatment, I actually am not safe to drive. With that treatment, I have no disability. So the CRC acknowledges that disability is about impairment plus the failure to accommodate for that disability or the inability to accommodate. And I've also put up for you Article 11 of that convention, because it makes it clear that persons with disabilities have rights in every single context: humanitarian emergencies and natural disasters. First time we've ever had a human rights instrument say this. Up until this time, would you believe it, the earlier conventions actually threw their hands in the air and said, whoa, there are some rights that will persist across every situation, but a lot of the political and participatory rights will be suspended if there are situations of emergency. So I've put up for you Article 12 for your take-home reading. Yes, the bad news is that there is only one country that hasn't signed the CRC, and it is America. In fact, you haven't signed you haven't ratified the CRPD either. You came 7 votes short in the Senate, which was absolutely tragic, because so many people, including the late great Senator McCain, fought for it tooth and nail. It was very, very sad. What I will say to you, though, apart from the fact that I think you should use this to guide what you do, the principle of best interest is accepted by so many countries. It underpins so much of domestic laws everywhere that the argument is that it's actually entered into customary international law, which is law erga omnes, applies in all circumstances, in all times. Disobey it at your peril. So I've made the point here on the slide that this is actually reflected in a lot of the state protection frameworks. But unfortunately, as we found in the seeking asylum research that I did between 2004 and 2007, children on the move, in too many instances, are seen first as migrants and only second as children. So I've put in here that US is party to, just so I don't want to depress you. You are party to the protocol relating to the status of refugees, and that of course is reflected in the Refugee Act, which is codified in section 208 of the INA. So I want to quickly highlight the problems that children everywhere face. I've given you a slide that really, it puts some context around where you need to be thinking about the best interests of the child. It's also like a checklist that tells us where they're not being regarded not being treated properly. Also, I think you'd agree, at point of entry, access to asylum. I could put access to country there. I'm from Australia. We have, look, I'm going to give you my checklist of what I think are the biggest problems at the moment, but let me just briefly give some structure to this, looking at really what I'm doing here is tracking the voyage, the travel of the child, entering a country, accessing asylum, the identification of vulnerability. That really raises issues about the very identification of a child. What tests do you use to work out whether a child is 15 or 18? Their interviewing and representation, how are children cared for during the asylum process. Unfortunately, Australia has a policy of mandatory indefinite detention up until a status of some kind is given to a child. I've also done a lot of work in the field. So when you go out into the countries that really host the big numbers, Jordan, Turkey, Pakistan, Uganda, the question there becomes, well, what are the durable solutions for children who are displaced in the field and when they get to countries like Australia? What's the difference between getting asylum here and getting withholding of removal? Who has access to family reunion? Who gets sent home? Okay, gaps in protection. We could spend a week talking about this, but I'm not going to. I'm going to just say that although the CRC applies across the world, arguably erga omnes as a principle of customary international law, in too many countries, migration status trumps protection. Or should I say, the discourse on deterrence trumps protection. So in Australia, for example, for the last 7 years, we have been interdicting, pushing back anybody who comes to Australia by boat, but we have set up offshore processing centres. Now, guess who we copied when we did that? It was America. It was the establishment of Guantanamo Bay. You may be aware that that was first established for asylum seekers who were pushed back from Haiti. Then it became a holding place for terrorists, of course. We sent ours to Nauru and Manus Island in Papua New Guinea. Get on your Google Maps and have a look where they are, because they're in the middle of nowhere. It costs a fortune, and it, of course, completely restricts the ability of anybody to get there. Most importantly, it's what Australia has done and what countries all over the world are doing. Europe is using Libya. I give you a few weeks until we see Mexico being used for the same purpose. We actually push people to these foreign countries and then say, we're no longer responsible. If there's an asylum claim, it should be done by Papua New Guinea or by Nauru. So for us, that is a really bleeding wound at the moment. If we go more globally, however, and we have a section of our book on this, which I think is very good. Sorry, I didn't write the chapter, so I can say that. There's an addiction to detention everywhere. In the US, you have seen forced separation of children from their families. We're seeing it in Australia. Finally, public opinion is turning against the sending people and children to Nauru and Manus Island. You know, we had a 6-year-old last year who attempted suicide. We have children with resignation syndrome, a syndrome interestingly, that has also manifested in children in Sweden. Children become catatonic, unresponsive, and they have to be force-fed and hospitalised. So we're doing an awful lot of damage, all in the name of really saving the putative child. We have to do this because we need to deter parents from putting people on the road. I think detention, for me, detention, separation of children and the denial of family reunion are some of the worst addictions that the world has at the moment. I've left you, as I conclude, with Article 37 of the Convention on the Rights of the Child, which basically contains both Article 3 of the CAT, so no child shall be subjected to torture or cruel, inhuman and degrading treatment. It has a prohibition on arbitrary and unlawful deprivation of liberty. That is particularly relevant to migrant children and to children with disabilities. You put migrant children and disability together and it's a catastrophic situation. So, for your delectation.
Thank you very much, Mary, for that elucidating section on the intersection between international law and the situation in the United States. We are now going to turn to the situation specifically at the border in the United States, how migrant children enter the country, how they're processed, what procedural and substantive rights they have, if any. I'll talk about that briefly, but I also just want to encourage participants to send in questions via the chat function on the webinar. We will have a section at the end for questions, so please do type in and I will make sure that they are entered into the queue. So I just want to talk briefly about what happens when a migrant child crosses the US-Mexico border. I'm going to speak specifically about unaccompanied children. The process for families crossing the border, as you no doubt know, is ever-changing. But Safe Passage Project deals specifically with children who arrived unaccompanied. So what we generally see is a child who crosses the border. They're not entering at ports of entry, mostly because I personally doubt that children know where the ports of entry are at the United States along the border. So they're crossing really anywhere they can. Many of them present themselves to Customs and Border Patrol agents, or else they are simply arrested on the US side of the border. They are arrested and detained in ICE, Immigration and Customs Enforcement custody. They are supposed to be detained if they are under the age of 18 for no more than 72 hours. That's the result of a consent decree as part of the Flores settlement. So there's a settlement agreement as well as subsequent federal court decisions that govern the treatment of unaccompanied children and really any child in immigration detention. So they're supposed to be detained in that very restrictive setting of an immigration jail for no more than 72 hours. They're then transferred generally to the custody of the Department of Health and Human Services, and specifically an agency within HHS called the Office of Refugee Resettlement. Now, the Office of Refugee Resettlement does, of course, what its name implies, which is resettle refugees. However, unaccompanied children have not yet been designated refugees. They're simply in the custody of this agency that is placing them in child welfare centers, foster homes, or the like. So those children spend some amount of time in a group home or with a foster family. And what is supposed to happen is ORR, Office of Refugee Resettlement, is supposed to look for a family member or a family friend who will accept the child into their home. Because the child is, again, per the Flores consent decree, supposed to be in the least restrictive setting possible, even if they are undocumented. What we're seeing, however, is the fact that the government or the U.S. government is really purposely exacerbating children's vulnerabilities here by lengthening the time of detention or preventing children from being released to sponsors by way of increased ICE enforcement. So potential sponsors who are undocumented, who have come forward to say, I will take this child into my home. We have unfortunately heard of situations where sponsors come forward, go through the background check process, and then are arrested by ICE. So not only is that sponsor now detained, the child remains in detention as well.
So this is Lenny Benson again. I'm going to jump in here to show you a slide that's a little bit out of date. People often ask the Safe Passage Project, why do you have so much work in New York when these children are arriving at the southwest border? This is based on data from the Office of Refugee Resettlement. You can see that New York is in the top 4 receiving states, and the children are joining one or sometimes both of their parents who are already living in the United States. Recently, Mary Kroc and I were in Washington. We had a discussion with someone who told us that in the past, about 60% of the children were released to one of their parents. Today, that appears to be dropping to 30% because, as Alex Rizzio just said to you a moment ago, many of the parents are very fearful of coming forward. Moreover, in the last few months, the government has required DNA tests, background checks, security clearances, even for parents, when we've not had that before.
And this is Alex Rizzio again. I'd just like to jump in to note and make sure that we all witness the phenomenon of really the forcible creation of unaccompanied children by way of the government's policy over the past year of separating children from their families after they cross the border together. So in general, those children would previously, under a different administration, those children would generally stay with their parents if they crossed the border together. But as we've all seen over the summer, the government was forcibly separating parents from their children and then treating those children essentially as unaccompanied. So Safe Passage Project represented over 60 children who had been separated from their parents and were transferred to ORR custody in New York State while their parents remained detained near the border or were deported, in fact, back to their home countries. But I am happy to report that all of the children that we represented were either reunited with their parents, that's the vast majority, or were released to an ORR sponsor, as was their wish.
So I'd like to turn now to more of the overview idea of why Professor Kroc and I wrote the book and why we're looking at what the U.S. practice is, how it's deficient. Professor Kroc's introduction of reminding us of the international law regime, the regional agreements at times, and the UN committee notes fly in the face of really what we're doing. While the U.S. statutes do offer some protection to unaccompanied minors and to some immigrant children, we use the cauldron, the hot spot of immigration court to adjudicate the claims for protection for these children. And our federal government appears to be insistent and demanding that only the federal government can make the decisions about the care and custody of the children. Our judiciary, as I'm sure this audience is aware, is under great pressure from the current administration to expedite and adjudicate cases on a more rapid basis. It is not an independent agency, and judges are on new quotas to perform. The Attorney General, in a series of actions this last spring, were gutting many of the procedural protections and in fact chose a case, matter of Castro-Tum, that was one of the cases of an unaccompanied youth to illustrate why a judge could not use something called administrative closure, a temporary closing of the removal process, to end a proceeding before a child who had not appeared before the court and was unrepresented. I think if you're familiar with this field, you know, however, that it's a very lopsided situation where we put the immigration judge in the courtroom. The government is fully represented by counsel, but the respondents only have counsel if they are lucky enough to secure free or pro bono representation, or if their families have managed to find them legal assistance. In the last few years of the Obama administration, which had dealt with a large number of unaccompanied minor children, they did authorize the lawyers who had contracts with the Office of Refugee Resettlement Agency to at least provide some legal assistance to the children. In the most recent administration, it's become a little bit more chaotic, where attorneys through those agencies are doing the best they can to assist children in detention, but detention by in of itself frustrates the children's access to some of the substantive relief. We have on the slide the phrase "no civil Gideon." That refers to our Supreme Court case, of course, that says an indigent person should have appointed counsel. And in 1964, the Supreme Court, in a case called In re Galt, said that states could not refuse to provide appointed counsel when children's liberty was at stake. What's happening today is our government is trying to frustrate the children's access to these multiple forms of relief that are on the screen. Quite often you'll hear people in Congress or in the administration say these children don't qualify for relief. That's not our personal experience. Many of the children qualify for asylum, of course. Some qualify for special immigrant juvenile status. I'll talk about more in a minute. But if you're in detention, the ability to process and proceed with an application for a U visa, a victim of crime in the United States, or a T visa, a victim of trafficking, or even have a relative who might be able to sponsor you access any of those petitions is extraordinarily difficult. And if you know our immigration court system, you know that the court lacks jurisdiction to adjudicate most of the forms of relief you're seeing on the slide. So we're using the wrong process to adjudicate the children's claims. And to me, that flies in the face of the Conventions on the Right of the Child. This was a very cheerful little infographic I made a few years ago, where I was lecturing a great deal about a wonderful status we have in the United States called Special Immigrant Juvenile Status. It was created by Congress to help children who were lacking both parents and the ability to reunite with their parents due to the abuse, neglect, or abandonment by one of those parents. It was a system where children could go to their state family court and either have a relative become their guardian or custodian, or the state itself through its foster care system. And then that child, once the family court judge, a judge trained in best interest of the child and in assessing children's situations, made recommendations of allowing the child to remain, the Immigration Service would adjudicate the other elements of the petition, and children would be on a path to a green card. You can see even in the cheerful infographic, it could take over 2 years. Today, we've put up chaos and a descent into hell. We're using the famous image by Bosch. We apologize to his heirs and descendants who might have a copyright. We're using this as commentary or satire. Those of you who work in SIJS know how at every stage of the process, our government has begun to frustrate access to this remedy. And I'm going to let Alex Rizzio comment on that.
So Professor Kroc talked at the beginning of this webinar about how to integrate the concept of the best interest of the child into laws intended to protect children. And special immigrant juvenile status was really one of those ways where Congress kind of ingeniously developed a system whereby the very courts that have experience dealing with best interest determinations are the ones making the bulk of the decisions. So state family courts are, in the SIJS context, supposed to be the courts that are issuing orders, doing fact finding and issuing orders that deal directly with the best interest of the child, and that is as it should be. The problem now, as we have descended into Hieronymus Bosch territory, the problem now is that USCIS is refusing to grant special immigrant juvenile status petitions for a variety of, I would argue, legally insufficient reasons. We've seen reasons ranging from the state court did not apply state law in its decision-making process. I think that is kind of a patently absurd explanation. Of course, a state court is utilizing state law in its decision-making. It cannot use any other form of law. We're seeing now that USCIS is interpreting state statutes regarding who is in fact a child for their own purposes. So denying SIJS petitions of children who are over the age of 18, even where state courts continue to have jurisdiction over children who are between the ages of 18 and 21, and even where the federal statute is very clear on its face in black and white that special immigrant juvenile status is available for children under the age of 21. So we unfortunately see this kind of one codified area of the concept of best interest of the child falling by the wayside as agencies attempt to override the black letter law that's contained within our immigration statute. So, Lenny, you and Mary, you've edited this book, you've traveled to other countries. Can you talk a little bit about what best practices you've identified in the course of your studies?
So just so the audience knows, I'm going to let Mary Kroc give us the happy version, and then we're going to descend once more, looking at what's happening at our border. Go ahead, Professor Kroc.
Yes, well, look, as I said before, I think one of the take-home messages from this webinar should be that much as we become totally engrossed in our own countries, our governments are talking to each other. They are swapping ideas, and generally they're doing it in a context that's not moderated by either academics or civil society in our respective countries. And I think that's a real shame. And I think if we become more aware of what's happening in other countries, it gives us more weapons to fight back and to argue, advocate against the changes. You know, as we were talking here, it made me think that I should have told you about another article in the CRC. So I just want to mention it very briefly. Article 22 of the Convention on the Rights of the Child makes express the fact that when a child is dislocated from their home and country, they should be treated as if they were refugees, even if they haven't been formally given that status anywhere. So that's another unique feature of the CRC that helps to explain why across the whole of Europe and the UK, which is trying to Brexit at the moment without much success as we speak, half of the government has just resigned, very interesting. Did you know that unaccompanied children in those countries are automatically put into their child protection systems up until the age of 18? Now, that's good and it's bad. It's bad because, hey, your asylum claim is going to be strongest at the time that you leave. If you have to wait 2 years, 5 years, 7 years, 15 years, what is your status then? So good and bad is the answer to what a lot of countries are doing around the world. Best practice in your region, straight out Canada. Oh, Canada, if I've got any Canadians online, God bless you. Canada has always been a leading light in the asylum area. If there are Canadians, I can see them starting to scratch at the table though and say, but. The point is, every country has made small steps towards protecting children on the move, but there's always a long way to go. So Canada, like Australia, like the US, has also been drawn into this detention debate. I think, as an outsider, that their practice is very good. New Zealand, in my region, is the Canadian equivalent against big, bad, ugly Australia. Tiny little New Zealand is so generous and keeps offering to take our children from Nauru. As of today, there were only 20 left there. Just as a FYI, we've been bringing the children back from Nauru to Australia, but then separating them from splitting the families, basically.
Professor Kroc, before you go on to talk briefly about your work on refugees with disabilities, I did want to say, for those of you not familiar with the book, and you can follow this link, if you have an institution and you purchase the book, it is free download for anyone in your domain, so a library, an institution, a university. But the chapter that we're describing on Canada, written by Geraldine Sadoway, is very, very important reading, I think, for any of us doing advocacy work in the United States, because it's such a contrast to our own system in its provision of counsel and other aspects of making sure there's medical treatment and assessing the needs of the child both physically and psychosocially. So turning to why we have a slide up about disabilities, could you speak to that briefly?
Thank you, Lenny. I've just come off doing a 6-country survey of what happens to persons with disabilities when they travel. The short version is that for too long, persons with disabilities have really been forgotten and invisible, in the sense that just as those of us who teach, if we ask the class straight up and say, please put your hand up if you have a disability, how many people do you think do that? Answer, nobody. There are myriad reasons why refugees who don't have a disability that's bleedingly obvious, excuse the pun, so if they're blind, if they've lost a limb, you'll know straight away that they have a disability. It's the psychosocial and the invisible, even deafness and hard of hearing, you can't see that. And if you don't ask, you won't find out. And so the point of our research was really to look at a method to get this information out of people. Because if you don't know that, I'll just quickly whip through it with you, because you as practitioners, I think this is really important to know. If you go and ask your clients, have you got a disability? I will tell you now that most of them won't admit it or won't volunteer it. But if you ask them about their functioning, how's your eyesight? Can you hear? When did you last eat? You know, how well are you sleeping? Can you think clearly? Then you will get the real answer about how well these people are dealing with the situation that they're going through. And with children, again, going back to the work I did back as far as 2004, you ask a child, are you afraid? And they'll say, no, I laugh at fear. No, I laugh at danger. They won't admit it. There's so many things that kids, particularly teenage boys, but teenage girls are just as bad sometimes. So you've got to, if you're trying to get stories from people, from children rather, you have to be aware of this and really think about how can I flip this around to tease the information out in a way that is not going to be judgmental, or that the child will think that you're labeling them in some way.
So, Lenny, I'm wondering if you can now focus a little bit on changes in procedure and substantive rights affecting migrant children in the U.S.
Sure. We only have a few minutes left. We definitely hope those of you who are on the webinar will write to us, and we'll send you an email later today, again, with our slides, with information. And the Safe Passage Project website also has some really amazing resources that are free and available for those of you representing children for asylum. But the most recent changes, I think, that are dramatically affecting, we see the images here of the government building tent city camps in the Texas desert. And whether or not those children are getting any access to counsel at all is debatable. They're certainly in violation, I believe, of the standards of federal law, let alone international law, by this detention and the terms of the detention. I am in great fear that even without congressional authority, our government will begin to treat these youth in the same manner that they do Mexico. We have a safe third-party agreement with Mexico, which means that children are screened excessively briefly and pushed back. So in one of the slides we'll send you, you'll see the number of Mexican children that arrive every year. Almost 100% of those are pushed back immediately. For a long time, our administration has wanted the authority to repatriate to these children without doing any assessment at the most highest level of protection, such as Convention Against Torture. The other big change that we're seeing is the presidential proclamation of last week. The constitutionality and legitimacy is already in litigation about this, but I believe that Mr. Trump has recruited better lawyers than he did in his original Muslim travel ban. The proclamation is written quite cleverly and says that if you arrive irregularly across not a port of entry, you are banned from seeking what we call asylum or refugee protection, while you still might have access to the higher burden of proof standard of protection under withholding or the Convention Against Torture. That looked remarkably familiar to me, as did the agency's proposed regulations on new detention, prolonged detention, potentially indefinite detention. And I'm going to turn it one last minute to Professor Kroc, because where did these ideas come from?
Yeah, like I said, our governments are talking to each other, particularly conservative to conservative, so Republican to the equivalents in Australia and the UK. They're actually meeting formally in Geneva, if you want to know, at the Intergovernmental Consultation on Migration. And one of your great bureaucrats actually heads that up. And in fact, I don't know a better advocate for the best interests of the child than that particular person. So all around the world, you see this new idea that if there's an obligation to protect people who are on the run and in need of protection, that protection doesn't have to be permanent. It need only be temporary. And so the difference, as you would understand better than I, asylum gives you a green card straight away. Refugee protection in Australia, if you have come in lawfully and you change your status, so as an affirmative claim in Australia, you get a green card there as well. But these people who are coming without a visa and crossing our borders and causing such political maelstrom, in Australia, you have no right to claim asylum. They have no right, in fact, to ask for any form of status, unless one man, and it is a man at the moment, his name is Peter Dutton, he's our Minister for Home Affairs, allows an application to be made. And if and only then they're found to be refugees, then they will be given temporary protection. And this, I think, is what Trump is looking to do here too.
So basically, Australia's excised this entire border if you arrive irregularly, and the United States appears to be doing this. Although the good news in the proclamation, again, besides the litigation, is it is only a 90-day issue. And I think some of you saw the news reports that at first the government was telling the press that this did not apply to unaccompanied migrant children, and then apparently they read their own proclamation and saw that it did. So my fingers are crossed that the litigation will be successful, and we hope that part of the seminar was as well to make sure that in our advocacy, in writing comments on regs, in writing briefs to federal courts, in writing to the immigration courts, you'll be able to use some of these instruments that we've given you under the Convention on the Rights of the Child. Use the book, we hope you will, for resources, footnotes, citations, and particularly I'd like to redraw everyone's attention to November 17th of last year, when the Joint Committee at the UN on the Rights of Children and on Migrant Workers together articulated what is the minimum that children deserve. We are so far away from that minimum in the United States that I really feel if we educate ourselves better about this, we'll be able to advocate to the new Congress, at least portions of it, advocate to courts, advocate to each other for a better future. So I'm turning it back over to Alex Rizzio for closing remarks.
Yes, I'd just like to make one final plug. If anybody has questions, please use the chat function. Excuse me, please use the chat function on the webinar software. Lenny, I actually, before closing remarks, I had just a quick question for you regarding the presidential proclamation. To me, the language of INA 208A1 is very clear, right? It says specifically that anyone in the United States, whether at a port of entry or not, is eligible to apply for asylum. How do you think the administration's new lawyers will argue against that particular provision in court?
Well, I don't believe ultimately that they'll be successful in the district court or perhaps in the Ninth Circuit, where I believe the challenge was made. But I'm a little bit afraid about the Supreme Court. And that's because there's a case called Sale v. Haitian Refugee Center, which said that although the statute does indeed give you a right to seek asylum when you're at a port of entry or at the border, if we interdict you before you reach our territory, then you cannot have that statutory right. So the proclamation is trying to expand the bubble, the shield, and outsource or excise our border. that's where the physical difference appears. Children who actually are out crossing our border and into our territory should be recognized. And I believe that's true even in our 1996 statute about expedited removal and the proclamations that tried to expand expedited removal at 100 miles into our territory. The problem is we didn't have the ability to litigate that because of the context of the expansion by Attorney General Thornburg and Attorney General Ashcroft. So ever vigilant, the groups that have filed the suit, they're going to be challenging that. And I'm optimistic, as I said, in the lower courts. However, should the current Supreme Court reach this, I could see them acting in a way we often see in immigration law of saying the president's authority to maintain national security and the maybe distortion of the provision found in the temporary suspension of admission and visas. If the president keeps calling this a temporary suspension, perhaps that will be allowed to be an exception to the rights Congress has given under Section 208.
Thank you, Lenny. And Professor Kroc, do you have any final remarks you'd like to add?
I would like to leave you with some encouragement. We in Australia have lived through some real nightmares. It's at a much smaller scale than it is in the US, there's no doubt about that. But if you're a single child, then the damage that is done in Australia is no less harmful than the damage that is done here. I would just like to make a comment to you about litigation, a strategic litigation in this area. What I have found over the years is that the really big ticket litigation where we've gone in with all guns blazing, cited the Convention on the Rights of the Child, the Convention Against Torture, the Refugee Convention, our highest court has tended to do exactly what your government and courts has done, namely to say, don't talk to me about international law. This is our domestic law. The most successful litigation I've found has been very carefully calibrated arguments, taking elements of the law and trying to avoid some of the really big ticket arguments about executive power or whatever. So it's worth bearing in mind. It's why you are and will continue to be important, but you have to really, as you go into this era, think very strategically and use all of the weapons that you actually have in the legislation, because often the little incremental argument will get the child that you're looking after over the line. If you're trying to make, the big precedent, it really often doesn't work.
So with that, I'd like to thank you all for listening in and joining us. We will be emailing to all participants the slideshow, various links, and the first chapter of the book, Protecting Migrant Children. If you have any follow-up questions, please do feel free to get in touch. And thank you all so much for joining us today. Especially thank you to Professor Lenny Benson and Professor Mary Kroc for sharing their expertise.
Thank you, Alex.
Thank you, everyone.